Am I audible to all of you? Yes? Okay. So, very good morning to all of you. I'll be your tutor for corporate and business law. And I'll just give a brief introduction about myself. I'm Arfeen Usmani. I'm a member of ACCA. Currently, I'm working in an MSc, and I have been the tutor for APM as well in VG Learning. So, yeah, this was all about me. And I would like to introduce you all to introduce yourself, if you could do so. If any one of you is speaking, so you all are on mute.
Hi, ma'am. Good morning.
Good morning.
Am I audible?
Yeah, you're audible.
Ma'am, myself Asik Singh, and I'm from Nepal and currently living in Pune.
Okay.
Yeah, and I have completed my 12th from Kathmandu, Nepal, as from science
Okay.
background.
Okay. So
Yeah.
have you attempted any exam for ACCA before this?
Yes, three of them: BT, FA, and MA.
Okay, so you're aware about it.
Yes.
Okay. Anyone else? Nice to talk to you.
Thank you so much, ma'am.
Hello, ma'am.
Hi.
Myself, Divyansh Mehta, and I have
Oh,
completed my senior secondary education from district Fatehbad, Haryana,
okay.
and I have appeared for the exam MA, FA, and BT, and
Okay.
I have cleared also.
Okay. Okay.
Yes, ma'am.
So it's good you all are aware about this ACCA CB platform and all you are aware. Okay.
Ma'am, but about CB platform, not much, and
Okay.
about study, we are aware. Study hub, we are aware.
Okay. Okay. Okay.
Yes.
Anyone else would like to give an introduction?
Hi,
Hi.
I'm myself Irfan Nisa. So
Okay.
basically, I'm from Kerala and
Um,
I'm an MBA graduate in finance. Uh,
okay.
Currently, I'm working at Goldman Sachs, Hyderabad.
Okay.
So, and I would like to build my career in finance. So that
Okay.
is the reason
Great. Then
I
ACC is
joined.
a very good option for you because it
Yeah,
has lots of opportunity. Yeah.
yeah, but I didn't give any examination yet. Uh,
Okay.
this is this this is the first paper I choose to give my
Okay.
exam. Yeah.
Okay. So
So
current, yeah.
I need your help and support because I'm working and studying. I
Mhm.
know that by attending your class, I will be
Mhm.
well versed to write this exam and clear
Yeah,
it.
I will try to make the subject very easy for you so that all of you are going to clear it well. And I'll
Yeah.
guide you in terms of ACC also how to proceed. If you need any sort of help, you can contact me anytime. So yeah,
Okay. Thank
okay.
you so much. Thank you so much.
Anyone else wants to give an introduction?
Hello,
Hi.
my name is Roshan. I live in Mumbai. I've
Okay.
cleared my PT, FA, and I'm yet to clear my MA. I'll give this
Okay.
exam this month, and
Okay.
now I'm studying for this law subject next week.
Okay. Nice. Okay, now I'll give the brief introduction about the subject. So what is all about. So right now I'm sharing my screen. Okay. My screen is visible, right?
Yes, ma'am.
Okay. So this is the corporate and business law page. Once you'll go to the ACCA study resources on the Google, simply if you're going to type like corporate and business law, ACCA, you're going to come this page. So once you open it, you're going to see that the exam resources are being given, like the introduction to corporate and business law, the examinable documents, the examining guidance, the syllabus. And in terms of learning and revision, you're getting the ACCA Study Hub, the practice test, which you can do it afterwards, like after completing your syllabus. The specimen exams are being given, and all these are being there for your help. So let's look at the introduction to the corporate and business law.
Ma'am, video is not audible to us.
So this was the introduction which is being provided by the ACCA itself. So once you, as I was telling you about the CBE platform, so this video will guide you in respect of that, okay?
So it's important to be familiar with the CBE platform.
The video is not audible.
Is how to put permitted characters in numerical answers. If
Yes,
a decimal point is required, then you need a full stop.
video is not audible. Can you please repeat?
Ma'am, now it is audible.
Okay. I just restarted, okay?
And if a negative is required,
Ma'am, whenever you mute yourself, it's not audible.
and then you've got other features showing you the flag, remove the flag, references and help. We're now going to start the exam. Here is the first question, and I'm going to explain the toolbar at the top first. Question 1 shows you that it's for 2 marks. You have your time remaining next to that. You have your exam completion bar in the middle. At the moment, we've done nothing, so it's 0% complete. And then you can have your test progress details to show what you've completed, what is incomplete, and what is flagged. Down here are your references. So if you have a formula sheet, for instance, the next one is the help icon, which goes through those help screens again that you saw earlier. And then we come to the flagging function. I'm going to flag this question because I don't know the answer. I'm now going to go to the next question. And notice this one is also for 2 marks. I'm going to complete this one, just have a guess. And in this specimen exam, it will tell you whether it's right or wrong. But in your real exam, it won't tell you that's wrong. You just have to keep going, thinking that you may have got them right. And then I'm just going to show you the progress chart again. It says 6% complete. That's because I've completed 3 questions and I've flagged 1. Once you've completed the exam, then you would simply exit. It tells you that you've got incomplete questions. Do you still wish to exit? Yes. And then you get your result. And this will be uploaded to your account within 72 hours.
So this was all about the introduction to the subject, like a brief introduction and about the CBE platform. So let's look at the other parts. Like here, the examinal documents are being given, which you can go through it. After like completing your syllabus only, you'll be able to understand what is it all about. And then the examining team guidance, which specifies like what is their review points in terms of the answers which is being attempted by the students. So you can see this also. Now comes the syllabus part. So as it is global, so you have to choose global and then view. So basically the aim of the syllabus is for you to develop the knowledge and skills in understanding the general legal framework within which the international business are taking place and of specific legal areas relating to the business, recognizing the need to seek further specialist legal advice where necessary. So basically this subject, corporate and business law, is being divided into 8 areas. So the syllabus, it starts with an introduction to different legal systems, different types of law, and those organizations which endeavor to promote internationally applicable laws. So it also introduces arbitration as an alternative to court adjudication, and then examination of the substantial law as stated in UN Convention on Contracts for the International Sale of Goods. So basically different chapters are being given. So once you will complete that chapter, then you will be able to understand what is being given over here. Then there are also laws which are relating to the financing of international transactions and the various legal forms through which international transactions are being conducted. So overall, it will be very helpful for you, the subject. And so the syllabus will be divided into like different parts, and according to it, different chapters are being there. So in terms of essential elements of legal system, that is business, political and legal system is there, international trade, international legal regulation, alternative dispute resolution mechanism. So this is all the part of essential legal system. Then international business transactions. So these 2 chapters fall under this, and transportation and payment of international business transaction, the formation and constitution of business organization, the capital and financing of companies, the management and distribution of the regulation of companies, and the insolvency law, corporate, fraudulent, and criminal behavior. So these are your chapter for the subject. And in details, this is being provided. So I'll share this PDF with you on the group, so you can go through it thoroughly afterwards. So yeah. So this will be like 25, 2 marks objective. As this, you must be aware that this is an objective exam, right?
Yeah, ma'am.
Yes.
But it is fully objective or only 70%?
Full objective, like you're going to, like all 4 options will be given and you have to select 1 or 2 depending on the requirement of the question.
Okay. So I just wanted to confirm one more thing. Can I please? Yeah. So I am having the previous year book. So the syllabus will be different for this year, or I can continue with that one. Like 2023 to 2024 book I'm having.
So as I'm seeing, the amendment is basically in the section code-based abjudication. So I don't think so much. I've also gone through it. No major changes are there, very minor changes there. You can, I
Okay.
think so, continue with that book, but if it is required, I'll let you know, okay? Till now, it's not
Okay.
required. If any changes are there, I'll update you on that,
Okay.
okay?
Thank you so much.
So in section A, you will be having 25 2 marks objective test questions and 21 mark objective test questions. And in section B, you'll be having 5 question of 6 marks. So it will be multitask question. A scenario will be given to you. According to that, different requirements will be given. That will also be your objective, but like scenario based will be given. Okay. So all over your 100 marks is totally objective. So you have to be very thorough with your subject, because you know in objective you can't leave anything. So you have to go through it all very well, right? Any questions so far? If anybody's having any doubt or any question, you can ask me.
We will study from BPP, or
Yeah.
you will give us notes.
You will study from BPP, and these questions, if it's there, like I'll make you solve after every chapter, all the practice questions, so you are like well aware like how to proceed. And yeah, you have to refer the BPP book,
Okay, ma'am.
the revision kit. The revision kit I'll be solving in the class as well.
Okay, ma'am.
So this exam is on-demand exam or session-based exam? I think it is on-demand, right?
Yeah.
So just like BT, FA, and MA, you can give it
No,
whenever.
this exam, like law exam.
Yes, yes.
No, it is a session based. This is session based. Your
Okay.
voice was clear earlier. Yeah.
Ma'am, according to me, ma'am, it is a skill level only exam which is on demand.
This
Ma'am, yes, this
I
law
have
exam
to
is on demand. Ma'am, yes,
yeah.
there are four on demand exams, three of
Yeah.
knowledge level and one of skill level, and
Okay.
rest ones are sessional based.
Yes, I have
Okay.
also heard that. That is why I wanted to confirm.
No, I'll just confirm you on this, okay?
Okay, ma'am.
Yeah, is my screen visible?
Yes, ma'am.
The book would be visible for you, right?
Yes, ma'am.
So yeah, this is the practice and revision kit of VPP. So I want you to have a look at this video because this will make you, this will guide you very properly. Okay.
Hello and welcome to this short introductory video, which is part of your corporate and business law course. This video will give you a brief introduction
audible,
to
right?
both the English and global variants.
Yes, audible.
It is audible.
Let's begin by having a look at the syllabus that you're going to be studying. You can see that there are 8 syllabus areas going from A all the way down to H. It's important to note that the first 3 syllabus areas, A, B, and C, are tailored to the specific requirements of the English legal system or the global business environment. Syllabus areas D through to H are identical, regardless of which variant you are studying. So let's have a quick run through the various syllabus areas. The first syllabus area, A, is on essential elements of the legal system, if you're studying the English variant, and essential elements of legal systems, if you are studying the global variant. So in the English variant, your study focuses solely on the English legal system. It looks at what law is and how the legal system operates. It also describes the various sources of law in the English legal system. The global variant takes a wider global view of things. You will firstly look at political and legal systems from around the world before looking at the ideas of international trade, international legal regulation, and how laws between countries can be in conflict. And you will also look at some alternative dispute resolution mechanisms that can be used in the global business environment rather than going to court. For both variants, syllabus area B focuses on contract law. However, as you'd expect, the English variant focuses on English contract law, whereas the global variant looks at contract law from a global perspective and focuses in particular on the UN Convention on Contracts for the International Sale of Goods. It also looks at the specific obligations of sellers and buyers when conducting international business transactions. However, in regards to contract law, the overview is the same. Both will look at how contracts are formed. They will look at the content of contracts and look at the circumstances that can cause a contract to be breached and the remedies available to those who are subject to a breach of contract. However, the English variant goes a little bit further and also looks at the law of torts, and these are civil wrongs and the idea of professional negligence. Syllabus area C is where the main differences between English and global variants are. If you're studying the English variant, you will look at employment law in the English legal system. In particular, you're going to look at contracts of employment and the duties and rights of employees and employers. And you will also look at dismissal and the various remedies for where employees are unfairly or wrongfully dismissed. You will also have a look at what redundancy is and the remedy available for that. If you're studying the global variant, you will continue your study of international business transactions by looking at the various transportation documents that are involved in international trade. And you will also look at the various methods of making payments across international borders. As I said previously, syllabus areas D through to H are identical. So whether you are studying the English or global variant, you will be studying exactly the same material. And all this material is related to company law. And in particular, both variants take the English legal system as exemplar and focus in particular on the Companies Act 2006 and various other pieces of legislation and law under the English legal system. In syllabus area D, you will look at how companies are formed and how they are constituted. In particular, you'll begin by looking at agency law and how partnerships are formed and are an alternative method of running a business and then running a company. You will then look at the idea of incorporation and legal personality before looking at the various procedures that must be followed to form a company. In syllabus area E, you will look at the capital and financing of companies. This area is split into 3 areas. You will focus firstly on share capital and the rules about issuing shares. You will then look at loan capital, which is essentially how a business borrows money and how loans can be secured on business assets. And finally, you will look at the idea of capital maintenance, which is a principle that is aimed at protecting the interests of creditors. And you will also look at the rules on when a company can declare and pay a dividend. Syllabus area F focuses on how companies are managed and administered. In particular, you will firstly look at the role of company directors in running the business and other company officers such as the company secretary. And you finish this syllabus area by looking at the rules concerning company meetings and resolutions that can be passed. Syllabus area G looks at insolvency law, and in particular, how companies can be rescued from insolvency through the process of administration, or if they cannot be saved, or if the company decides that it should be wound up, we will then look at how companies are liquidated. And finally, we conclude our studies in syllabus area F by looking at corporate fraudulent and criminal behaviour. These are the various criminal offences that can be committed by those running a business or involved in business. For example, we will look at issues such as money laundering, market abuse, and bribery, as well as some offences that can be committed when a company is insolvent. So let's have a quick look at the format of the exam. And the exam is the same regardless of which variant you have chosen to study. The exam will be computer-based. All the questions in the exam are compulsory. You have 2 hours to answer the questions, and you need to score at least 50% to pass. Now, your exam will have 2 sections, Section A and Section B. Section A contains 25 questions worth 2 marks each and 20 questions worth 1 mark each. So there is a total number of marks available here of 70. It's important to note that the 21 mark questions are highly likely to be multiple choice questions, which require you to select 1 correct answer out of 3 options. The 2 mark objective test questions could be in a range of different question formats. There could be multiple choice questions, but this time would require you to select 1 answer out of 4 possible options. You might also face multiple response questions where you have to select 2 or 3 correct options out of a range of possible answers. But you also should be aware that questions could involve a different range of question formats. You may be required to use drop-down menus to answer questions, and you may have to even match answers to statements. In section B, all the questions here are known as multitask scenario questions. You will face 5 questions in this section, and each of those questions is worth 6 marks each. So there's a total amount of marks available here of 30. Each of these questions will be based around a short scenario of a paragraph or 2 paragraphs of information, and then you will have to face maybe 2 or 3 sub-questions on that scenario. Questions here are likely to test your knowledge, but also your application, and this is where the extra marks can come in. So you could have a scenario question which has 3 subparts, in which case each of those subparts will be worth 2 marks each. So you could have a scenario with 3 MCQ questions. However, you may find that you have a scenario question with 2 subparts, in which case you could have a question which is a 2-mark MCQ, and the second question could be a 4-mark question that requires you to select a number of different correct answers. This means it's key for you to practice as many different questions as you can throughout your studies to become familiar with the different types of questions that you might face. So thank you for watching this short video. We would like to wish you all the best with your studies and good luck with your...
Got clear with it? Okay. So if I'm going to ask you, what do you understand by the term law? So what will you answer? Any one of you? Yes, rules and regulations. It would be great if you can unmute yourself and speak instead of writing. Then all of you could hear.
Law provides us rules and regulations which an
Yeah.
individual have to follow.
Yes. Basically, it is a system of like rules and principles which is being established and enforced by the governing authority in order to regulate the behavior within a society, right? So basically, what we are going to study is the corporate and business law, right? So by the name which we understand that it ensures that the business is operating within a legal framework and it is providing fairness, right, transparency and accountability. So this corporate and business law, what does it do? It protects the interest of the stakeholders, including its owners, the employees, the customers, and the public, right? Yeah. My screen is visible, right?
Yes, ma'am. It's
So law is basically a rule of conduct which is being developed by the government or the society over a certain territory. It follows the certain practices and customs in order to deal with the crime, the business, the social relationships, the property, finance, and etc. So the law is basically controlled and enforced by the controlling authority, right? This is all about the law. Now let's look at what is corporate law. So corporate law, it includes the law about the companies. As the name signifies, corporate means it is relating to the companies. About the companies, their formations, the operations, the mergers, and the acquisitions. For example, when a big company, it looks to buy a smaller company, so the two companies want to join together. Or an investor tries to put money into a startup, they look to corporate law to know how to legally conduct the transaction. Basically, it acts as a guiding point. So people in corporate law, they carry out everything needed to complete these transactions, from legal research to reviewing the final deal. So entry-level corporate law is what they do. They often conduct the legal research and the due diligence. So legal research means they research what laws apply to the clients and how those laws might affect the transaction. And due diligence, what does it mean? It means they look into the corporations at play, specifically things like the debts, the assets, the employment contracts, and the compensation agreements. Now, what is business law? So the word business and law, they make into the term business law. So business law is a body of regulation that controls how business is going to operate. It addresses contracts, agreements, and the strategies for concept protection. Without business law, so the business, the production, and the retail sector would all be ruled by the dictators, making it an essential part of law in general. So the goal of combining law and the business is to provide the safe and effective working environment for all parties involved in an enterprise. So business must manage a plethora of legal factors that impact their operations and interactions in the complicated world of modern commerce. So don't you think business law and the corporate law is very essential? Right?
yes.
So a fundamental aspect of company activity. So business law comprises of range of legal guidelines and rules which are intended to control business operations. So business law, they offer the legal framework which is necessary for promoting fair competition, safeguarding intellectual property, upholding worker rights, and supporting moral business practices. So this framework extends to the creation and management of organizations as well as the negotiation and enforcement of the contract terms. So why is business law important? So what are the reasons which make it so important to have? First is the legal contracts and the agreements. So for commercial operations, in order to run them smoothly, legal contracts are very necessary, right? And following the law is critical. So experts in business law assist organizations in creating efficient and error-free agreements, joining and making a contribution to an internal legal team, which requires an understanding of the commercial law. Then comes understanding of the business regulations. So understanding business regulation, it enables managers to run their companies more efficiently and steer clear of needless legal troubles. It makes them easier to comprehend the terms and condition of the commercial agreements. So a business law, what does it do? A business law degree makes it possible for business to operate legally and make it easier for business owners to handle legal issues. Now comes the fair compensation practices. So a legal foundation for open compensation practices is established by the commercial law. So it guarantees that workers receive equitable pay, benefits, and the entitlements. So commercial law, they establishes guidelines for the employment contract, the anti-discrimination laws, and the workers' rights in order to preserve industrial harmony and
Voice is not coming to everyone or only me?
Ma'am, your voice is not coming.
I think you are on mute.
Till now, I wasn't. Were you able to hear me?
No, no.
Oh,
No, ma'am.
and you didn't inform me. Like, okay, I'll just repeat it once again. Okay. So first was the protection of the shareholders, right? Right. Okay. So through the establishment of the legal frameworks that guarantee corporate governance, openness, transparency, and the fairness. So business law, what does it do? It plays a critical role in defending shareholder, right? It forbids possible management abuses by outlining the rights of the shareholders to dividends, transparency, and decision-making involvement, right? So various types of business law is the immigration, the employment, the contract drafting or negotiations, the antitrust, intellectual property, data security law, international sales law, and the bankruptcy. So the both corporate and business law, they apply to the business entities, right? Which means that they also
Excuse me, ma'am, what is antitrust?
business entities,
Antitrust.
antitrust.
Yes, ma'am.
So anything which is causing like harm to the security, confidentiality of the companies, the information, the documents, so antitrust laws are there.
Okay, ma'am.
Yeah. Which means that they only include the sole proprietorship, the limited liability companies, and the partnerships. So as corporations are a type of business entity, sometimes the difference between the business and corporate law can be confusing, right? So even though corporate and business law, they sound like they both cover the cases which is involving the companies, these are separate concepts that applies to individual cases differently. So the difference between the corporate and business law is as follows. That is, corporate law mainly deals with the action that can only be done by a corporation, which exclusively refers to a business that is being owned by the shareholders. And business law, it encompasses law pertaining to the taxes, the sales, the distribution, and the manufacturing, right? So the corporate and the business law, they both cover different aspects of the company's action that need to be held legally accountable, right? So these, once you are getting the clear concept, what is actually the corporate law and the business law, then you will be able to understand the subject more clearly, right? What is it all about? These two terms, right? Now I'm starting with the first chapter, that is economic, political, and legal system. My screen is visible, right? Okay. It would be great if you could please respond by unmuting yourself. So your first chapter to this subject will be your economic, political, and the legal systems. So in this chapter, we will be looking at the overall context, like what is economic, political, and legal, in which international law exists. So there is no all-encompassing global law as such. Instead, there are national legal systems of three kinds, that is common law.
Ma'am, can you zoom?
Actually, this is like from the application. So the options I was searching for it the same like Zoom option I was not getting. So I don't
Okay.
think so it will be, I'll
It
be,
is looking like small.
yeah. Even I was searching for the same, like the font size and all. I had tried ways, but it was not happening because I'm using through the bookshelf I had been provided by. But
Okay, ma'am.
are you all not able to see anything, or it's a bit of it is visible?
A bit of it is visible, but it is small.
Okay.
Yes.
So I'll just read through it. Okay. So there is no all-encompassing global law, right? Instead, there are national legal system of three kinds, that is common law, civil law, and the Sharia law. So these may be contradictory, creating the problem of conflict of law. And there are some model international laws that have been put together by international organizations such as the United Nations to resolve the problem. So in this way, the relations between the state and between the individual in different states are being regulated. So I'll make you see this if it gets zoomed. Right. Um,
मैम यहाँ पे टेक्स्ट साइज से हो जाएगा
I tried that, but the whole page is not coming in a fine way. If I'm going to use this. So these are already small, only it will come. But still, if it's visible, then it's fine for you all. Is it better? Because the font size is not increasing. It is to the application. If PDF was there, then it could have been done easily. It's not the PDF. So the economic, political, and the legal system. So the types of economic, political, and legal system. So it's the overview of the chapter. That is the types of legal system, the economic systems, the types of the political systems. Then under legal system, the law and legal system, the types of law. Under common law system is the common law and the role of judges. Then comes the civil law system, the Sharia law system. So all these we are going to study in the chapter. So now comes the types of legal system. Are you all having this book right now, the BPP book?
Not physical one, but I have ebook.
You have ebook?
Yes, ma'am.
Yeah, I have, ma'am, but that I told now, like the previous year. I can refer to that for now.
Okay. And rest of you? Are you all having the book or you all have what not now? Okay, you Raj. Okay. So first we are going to see the types of legal system. So although the law is a global concept, it is usually organized on national lines. That is, there is only a limited amount of truly international law. So in this course book, we shall be considering some national laws that have been example for other countries developing their legal systems. So from the exam focus point, if you are studying in a country to which we do not make reference, find out the origins of your notion's legal system so that you can compare it with the one we lay out here. Remember that you are not going to be examined on any nation's legal system. Rather, you will be examined on the principle of law that have the international significance, right? First is the common law, right? So the common law is a system which is being named after a historic system that was formulated in England. The terminology is being associated with this system can be confusing. So in common law, it is a legal system which is, you can say, characterized by the number of development of the law as through the judicial decisions which are being made or by the precedents rather than solely through the written standards or through the formal codes. So if I'm going to say about the common law, I'll just show you. I'm just sharing my screen. So in the simplest definition for common law is that it's a body of law that is basically based on the court decisions rather than the codes or the statutes, right? What are statutes? These are basically the formal written law that is being enacted by the legislative body, right? So what does common law means? Whatever the decisions are being made or being passed to the court, that is being considered as the body of law. You're not considering the code or the written statutes. But in reality, the common law is often more complicated than that. So at the center of the common law is a legal principle that is known as the stare decisis, which is a Latin phrase that roughly means to stand by the things that is being decided. So in practice, stare decisis is just a fancy way of saying that courts and judges, they need to follow earlier decisions and the rulings. Otherwise, they are known as the case laws. So when dealing with the similar cases later, right? So for example, if a court makes a particular decision that is being based on a specific set of facts, then the court is required to follow that decisions if they ever must make a ruling on the same or the closely related issue. Right? Clear till now? Likewise, decisions that are being made by the higher courts, like a jurisdiction Supreme Court, are typically binding on the lower court in the same jurisdiction. So this common law, we are going to study later in the chapter in a very detailed manner. I'm just giving you a brief so that you understand what it is all about, okay? Now, how common law is different from the civil law. So the two main legal systems, three legal systems were there. One was common law, the other was civil law, and third was the Sharia law. Common law, we know what it is about. Now let's see how it is being different from the civil law. The two main legal systems that is being used today throughout the world are the common law system and the civil law system. So what's the difference? While common law system, they basically rely on the case laws and legal precedents to guide their decisions. And civil law, they basically rely on the codes and statutes, right? What are codes and statutes? These are basically the formal written law that is being enacted by the legislative body. It could be the parliament or the Congress, right? Now, precedents, what do we mean by precedent? It is basically the court follow the principle that are being established in the previous judicial decisions that are being made depending on the case. So higher court decisions, they bind the lower court in the same jurisdiction, right? These are the precedents. specifically the civil law legal system, which was originated in the mainland Europe, centers around a comprehensive code of statutes that clearly outlines everything from the procedures for handling claims to the punishment for offenses. Clear? So if I'm going to ask you, what do you mean by statutes? So anyone could answer, what are the statutes, the legal codes and the statutes? Statutes are the basically formal, or you can say the written law, which is being enacted by the legislative body, right? It is the written document, which is being enacted by the legislative body. Clear? So simply put, civil law system, they have clear rules for how judges need to rule for many specific disputes, unlike common law system, where civil law court decisions are not binding in other cases, even if the facts are similar. What are the benefits of the common law system? There is no denying that there are pros and cons for the both common law and civil law legal system. But in the case of common law system, the benefits and the advantages include this. First is the stability and the consistency. How? Common law, they promote stability and consistency because everyone involved knows that the ultimate outcome will be based on the previous case law, whatever judicial hearing has been made, whatever the, you can say, whatever the case law have been decided. So based on that outcome, you know what will be the, the party will be knowing, everyone will be knowing whatever will be the ultimate outcome. And it is not on the subjective personal viewpoints. Then comes the efficiency that is given, that judges need only follow precedent when making decisions in the common law system court. So court proceedings can be much shorter, thereby saving everyone's time and money. Then comes the adaptability to the unforeseen. That is when lawmakers, they create statutes and the rules. So there is simply no way they can predict the countless situations in which courts may need to apply the laws. So indeed, it is impossible to legislate every possible problem or scenario, but in common law system, the court can address situation not which is being originally predicted by the lawmakers. Then comes the flexibility. So common law has also been described as flexible since it can respond to the changes in the society, unlike the civil law system. Common law doesn't require lawmaker to pass changes in the statutes and the codes, which can take a long time or never happen at all. So when it comes to the common law, higher court can and sometimes do overrule the prior decision as being the bad law, and they don't need to wait for lawmakers to do it for them. So let's look at over here what is being given. I've just for your reference, I've given you the understanding what is common law and civil law. So it is a system that is being named. The common law is a system that is being named after a historic system formulated in England. The terminology associated with this system can be confusing. So you will find that the legal system is named after one distinctive source of law within itself, but that the system they comprises several sources of law. So the common law system, it is being developed in England, but have been exported to many ex-British Empire and Commonwealth countries, notably for our purpose and the US. Then comes the civil law, which is being originated in the continental Europe, but have similarity being exported through world empires and so are equally prominent in other world areas, for example, South America. So civil law systems are much younger than the common law ones, although they come from equally old legal heritage. We shall use France and Germany as the examples of these systems. increasingly in the modern times. Civil and common law system, they share common elements, although historic differences still remain. Now comes the Sharia law, that is significantly, which is different from the both common and civil law system. It is legal system which is bound in the religion of the Islam, which makes it different in both purpose and the practice. It has influence in many Islamic countries worldwide and has been adopted as a comprehensive legal system in some. We shall look at two countries where such adoption has taken place, that is the Pakistan and the Iran. Okay, so as we have seen, the chapter is being divided into the different types of economic, political, and legal system, the legal system and the common law system. So what we have done till now, the types of legal system, right? Clear with it? So what are the various types of legal system which we have done? Can anyone reiterate?
Yeah, so common law system,
Yes,
civil law systems, and Sharia law system.
clear. Okay. Any doubt till here? Now let's look at the economic systems. So economics, as we know, it can be described as the way in which society decides what to produce, how to produce, and who to produce it for. So the decisions are required to be made regarding what resources should be used, right? I'll just highlight it for your reference. What resources should be used, how much we should be paid for them, what goods should be made, and what the price of the goods should be, right? For example, if you're planning to start a company, right, in any good, what decisions are you going to take? Like before starting a company or before deciding in which product you are going to deal in, for example, a business if you're going to start. So in which product you are dealing in or which services, for example, you're going to provide. So you all take decisions accordingly from before, okay? Before pursuing or before implementing your idea, right? Clear, right? Any response? If it's going to be an interactive class, then it will be a good one, right? It will be good for you also and for me as well.
Yes, it is.
Yes. So similarly, in economic system, so decisions are being made regarding what resources should be used, how much should be paid for them, what goods should be made, and what the price of the goods should be. So basically, there are three basic kinds of economic system, right? First is planned, second is market, and third is the mixed economy. So how you're going to get the question is, since it is not a proper subjective answer, you're not going to provide, you're going to give the objective answer. So it will be very specific. Any line will be given. You could be asked, what is this? Is it a planned economy? Is it a market economy? Or is it a mixed economy, right? So in a very simple form, I'm just telling you how it could be. Okay. So what is a planned economy? The planned economy exists where the decisions and choices about resource allocation are being made by the government. Clear? Although the individuals might be allowed to make some personal possessions, but most kinds of wealth uh, would not be available for ownership by individuals. So this is the planned economy. So if I'm going to say planned economy, so which countries do the follow planned economy? Any idea? By reading at you can say this definition of the planned economy, could you think any country which would be following this? Do you have any idea? Any guesses?
I'm not sure, but China is an example. I am not sure. I'm just
Earlier
guessing.
it was China. Earlier it was China. Now it is not China, but yeah, before 1978 it was.
Yeah.
It could be North Korea and Soviet Union. They follow the plan economy system. Okay. Now comes the market economy. So under market economy, it exists where the decisions and choices about the resource allocation are left to market forces of supply and demand and the working of the price mechanism, that is the price elasticity of demand, whether it is elastic or whether it is inelastic. So in the market economy, most wealth is being owned by the individuals with a minimum being collectively owned, right? So the decisions and the resource allocation are all these are being left to the market forces of supply and demand. So if I'm going to ask you by this definition, which economy would you think will be applicable? Market economy, which country?
All democratic countries.
Okay. So any example?
So like our India.
No. Don't you think at somewhere government intervention is there? Market
Yeah.
forces are also acting, but government intervention is there, which is a mixed economy. India is a mixed economy.
Yes.
Countries which follow dictatorship are following market economy.
Sorry, your voice is not audible.
Countries which follow dictatorship are following market economy, or countries which follow the decision as per
Dictatorship will go with the planned economy.
planned economy, yes, ma'am.
Yeah.
And India is following mixed economy.
Yeah,
Where
India is following mixed economy. And market economy, what do you think? Who is following?
market economy.
Who has the major, like, I would give you a guess.
No idea, ma'am, about market.
US is following market economy. Australia is following. Singapore is following. All of them are following market economy. Okay. And India is following India and UK, or now you can say China also is following mixed economy. In mixed economy, decisions and choices are being made partly by the free market forces of supply and demand and partly by the government decisions. Clear? So economic wealth is divided between the private sector and the public sector. In practice, all modern national economics are mixed economies, although with differing proportions of free market and centrally planned decision making from one country to the next. So we have done the types of legal system, the economic system, right? Now we're going to see the types of political system. So the types of political system. So the lawmaking can be a democratic process where law is being developed by the citizens, or a more dictatorial process. So where law is being developed by a government put in place by another method. For example, a military coup. So what process is in force in a nation also affects two very important factors, that is the rule of law and the separation of power. So what I'm going to do is, I'll just give you a 10-minute break right now. After that, we'll connect and continue with this chapter. Fine?
Okay, ma'am. Thank you.
Are you all back?
Yes, ma'am.
Okay. Shall I start the class? So now comes the types of the political system, which is like lawmaking can be a democratic process where the law is being developed by the citizens, or more a dictatorial process where law is being developed by a government that is being put in place by another method, or for example, a military coup. What is a military coup? It is basically a sudden or illegal seizure of a government by the military. So it involves throwing the existing political leadership or replacing it with the military authorities or their chosen leaders. So this is a military coup. So what process is in force in a nation, they also affects two very important factors, that is the rule of law and the separation of power. What do we understand by the term rule of law? It is basically that all institution or the individuals or the government, they are subject to and accountable under the law, right? So it ensures that law are being fairly and consistently being followed without any bias. So the rule of law says that how and what laws are being made and enforced in a country, it depends to a large extent on the emphasis that the country's political system they places on the nature of the rule of law. So this is the degree to which individual behavior is being regulated by the law. Now comes the dictatorial systems under the rule of law. That is, in dictatorial systems, there tends to be emphasis on the state or the government regulations and the control of resources. This means individual freedom is heavily subject to the rule of state-made law, and the behavior of individual is to large extent dictated by the state by means of law. Now comes the democratic system. In democratic, or you can say the laissez-faire political system, what does laissez-faire means? That business, they operate with little or no government you can say little or no regulations that allow the market forces like the supply and demand to determine the prices, production, and the distribution of goods. So in democratic or laissez-faire political system, the emphasis on the law being a means of sorting problem out where they arise, provided individuals, they act within the letter and the spirit of the law, and they are free to choose for themselves how they regulate their lives and how they relate to other people and the groups. Now comes the bodies that are being involved in law. So most democratic nations in the world have power in different places so that no part of the political system holds too much influence. So if I'm going to say, I'll just make you write and understand, or I'll just explain it from here. That comes the elected legislature first. So elected legislature, it is a body which enacts, amends, and repeals law so that the people wishes for freedom, wealth are being met. So it is a governing body which is being composed of the representative through democratic elections. Okay. Its primary function is to create, debate, amend, and enact laws that govern a nation, state, or the local jurisdiction. So elected legislature is like the members of the legislature are being elected by the people and represent the areas of the country in which they live. In the UK, Parliament is the legislature and consists of the House of Lords and the House of Commons. Now come the elected executive. It is a leader or a government body which is chosen by the public through democratic elections to head the executive branch of the government. So what is being given? Like a body that decides which laws to be put into action. A nation's head of state, a head of government are the two main roles in the executive. Working for the head of the government, often known as the prime minister, are normally a number of ministers of state with the responsibility for various government areas such as the defense, education, business, finance, and the foreign relations. So the executive, they does not make the law. Instead, it instructs the legislature as to what laws should be made, right? They provide their opinion or they provide the instructions what should be there or what amendments should be there. So in the UK, the executive is the political party that commands a majority of the House of Commons. In practice, the decisions of the executive are taken by the Prime Minister and Ministers of State. That is a group in the UK known as the Cabinet. Now comes the judiciary, which may or may not be elected. So a body that rules on any dispute about laws, whether between the government and the people, that is the criminal law, or between the individuals, that is the civil law. The role of the judiciary is to interpret and apply the law that is being created by the legislature. Clear? Now comes the separation of powers. As we have seen in the type of political system, whatever process is in the force in the nation, they affect two very important factors. That is the rule of law, which we've seen, the dictatorial and the democratic system, and the bodies that are being involved in the law. Now comes the separation of powers. So the concept of the rule of law, it is closely bound with that of the separation of powers. So in some nations such as the US, the legislature, the executive and judiciary are completely separate. All the elements which are being given, the bodies that are being involved, the three elements. In US, all of the three of them are separate. Therefore, each is accountable to and can operate as a check and balance on the other. In other states, such as the UK, there is a complex relationship between the three set of powers. This means that a balance is struck between the control and the accountability on the one hand, and actually getting things done on the other. So the other separation of power that is frequently is seen where the person who is the head of the executive is not as the same as the head of the state. Just we can look at the real life example. In the UK, the head of state is the monarch, while the head of the executive is the prime minister. In France, there is president and the prime minister. However, in the US, president is both the head of the state and head of the executive. Now comes the effects of the economic and political system on the legal system. So business activities, they take place within a particular economical, political and legal context. And each of these areas will affect each other to an extent. So the economic and the political context of each nation is not the same, although many groups of the nation are similar. And therefore, nations' legal system may vary considerably from one to another. Obviously, legal system will be different for different countries. So legal systems, now let's come at the legal system. So as we have seen over here, the types of economic, political and legal system, we have done the three subparts, right? Now let's look at the legal system, the law and the legal system and the types of law. So legal system can be used in two senses. That is, to describe the body of laws and mechanism for their enforcement in a country and to describe the underlying nature of the country's law. Now, law and the legal system. Law is a body of rules that enables society to operate, which we've seen in the slides as well. As such, it does not have to be written down, but can be simply rules that everyone in the society knows. So there are certain rules which we also, as a citizens of India, we follow, right? So many states have written constitution outlining citizens' basic legal rights and a body of national law or rules which govern how the state is going to operate. This is known as the positive law. So your question might come like a single mark question. Definition might be given like this, and you have to see, you could be given different kind of names of the law will be given, and you will be asked to write which is the correct, which for this definition, like many states have written constitutions outlining citizens' basic legal rights and a body of national law. which applies to this. So you're going to, different type of law will be given. So you're going to select the positive law. Okay. So you have to be particular in terms of definitions also. Fine. Clear?
Yes.
Okay. So a legal system in a country, it embodies both the laws of that country and mechanism the country has in place for regulating and enforcing those laws. So elements of the legal system. A legal system, they incorporates the country's laws, the legislature, that is the lawmaking body, the judiciary, the body that sits in judgment on disputes about the law, the prosecution system, that is the system that seeks to ensure the criminal law is enforced and people who break the law are being prosecuted. Prosecution, it refers to the legal process by which the government, through a prosecutor, they bring charges against an individual or an entity that is being accused of committing a crime. So a prosecutor, if you're going to ask, is say a representative of a state or a government, they initiate and conduct criminal case against the accused. Now comes the police, the body which seeks to enforce the law and protect the public. The prison system, the system that ensures people who have broken the criminal law are detained in accordance with their sentence. So the term legal system is also used to describe the underlying nature of the country's law. Now let's look at the types of law. So the main distinction that is to be made between the types of law are basically between the national and the international law. So under national law, each nation has a set of law which regulates how entities within it relate to each other and to the state, that is known as the national law. And in terms of international law, it is the system law of law that is regulating the relation between the sovereign states and the rights and duties they have with regard to each other. It attempts to resolve the problem of conflict of national laws. So what does international law deals with the matters such as the formation and recognition of the states, acquisition of territory, the war, the law of the sea and of space, the treaties, the treatment of aliens, the human rights, international crimes, and the international judicial settlement of disputes. So there are various sources of international law that are the convention and the treaties, international customs, the general principle of law that is being recognized by the civilized nation. So this is also important, the various sources of international law. Okay, you might get a question, the MCQ on this. For example, the European Union is a collection of nations which have agreed between them on some common law by signing conventions and the treaties. So this is public international law. You may also come across the private international law. This is the part of the nation's own law that establishes rules for dealing with the cases that involves a foreign element. Now comes the criminal law. A crime is being conducted, a crime which is being conducted is totally prohibited by the law. So the state prosecutes the case because it is the community as a whole which suffers as a result of suffers as a result of the law if being broken, if any crime is being conducted, right? So in a criminal trial, the burden of proof to convict the accused, they rest with the prosecution, right? I've explained you what prosecution is right now. So the prosecution must meet the standard of proof, which means that providing its case beyond its reasonable doubt. So punishment for committing crime, it is usually by means of fines or imprisonment. What happens if any person commits a crime, what punishment is being given to them? Either in the form of the fines, if it is a minor crime. If it is a major crime, then imprisonment is also given. Sometimes death sentence is also being given. So it depends upon the crime level, what kind of crime a person is committing. So, however, in some circumstances, the court may make a compensation order by which the criminal must pay some compensation to the victim or their family. This also happens. You can say the criminal is being asked to compensate the other party. Okay. So, some legal system based on the Sharia or Islamic law, they contains the concept of the qisas or the retribution. In certain cases, this give a legal right to inflict on the wrongdoer the same hurt that they have perpetrated on the victim, or to accept their compensation instead. These terms we are going to do in detail while we are studying the Sharia law. So this provides some compensation to the victim of the criminal activity who is not necessarily considered in Western law. So in the West, the focus of the law is mainly to punish the wrongdoer. Victim might have to undertake a civil law action to receive significant compensation. If you're going to look at the real life example, in the UK, police or the director of public prosecution did take the initial decision to prosecute, but this is then reviewed by the Crown Prosecution Service. In the UK and parts of the Commonwealth, a criminal case might be referred to as arraignment. The prosecution is brought in the name of the Crown. R signifies Rex, the king. Here the case law is being given, which you don't have to remember. In the US, it might be referred as the state versus Smith. Now let's look at the civil law. It exists to regulate dispute about the rights and obligations of the person when dealing with each other. It is form of a private law. As civil denotes the civilians. In the civil case, the claimant, they use the defendant. What do we mean by the claimant? These are basically an individual or the group or entity that initiates a legal action. Or you can say, or they demand for right, or you can say they demand for benefit or remedy in a legal proceeding. These are claimants. If defendant, it is an individual or a group or an entity that is being accused or sued in a legal proceeding. So in a civil case, claimant disuse the defendants. So it would therefore to be referred to as, for example, Smith versus Megacorp PLC, one of the most important areas of civil liability for business and accountants in particular is the law of trade and contract. For this, I'll just show you my screen. So Smith versus Megacorp PLC, I'm just explaining it to you for your reference, okay? So it represents a hypothetical legal case where an individual that is named Smith is suing a large corporation that is called Megacorp PLC in a civil lawsuit that is indicating that Smith is likely to claiming some form of legal wrongdoings by the Megacorp. Okay, it is all a hypothetical legal case. It is not a real case, such as the breach of contract, negligence, or the discrimination, depending on the specific details of the case. So key points about the case format: Smith, that is represent the plaintiff, the individual that is bringing the lawsuit against the Megacorp, versus V/S, abbreviation for versus, signifying the opposing party that is in the legal case. Megacorp PLC, it represents the defendant, the company being sued by Smith, that is the accused. So possible scenarios for a Smith versus Megacorp PLC case could be: first is, while it is, you can say a case law for the, you can say the employee, for example, or you can say company. So what will come first is the employment dispute. So Smith might be a former employee of Megacorp alleging wrongful termination, discrimination, or unpaid wages. Then comes the product liability. Smith could claim injuries that is being caused by the defective product manufactured by the Megacorp, or the consumer protection violation, that Smith might argue that Megacorp is engaged in the deceptive marketing practices. What are the important considerations from this? Like specific legal claims, to understand the full context, one would need to know the specific legal claims that is being made by the Smith, right, against Megacorp. All this is hypothetical, so hypothetical, you can say the conditions are being taken, such as the breach of contract, negligence, or the violation of a consumer protection statute. Then in terms of jurisdiction, the law and the procedures applicable to this case would depend on the jurisdiction where the lawsuit is being filed. Now comes the distinction between the criminal and the civil cases. So it is not an act of event which basically creates the distinction between the criminal and the civil cases, but the legal consequences. A single event might give rise to the criminal and the civil proceedings. That is the real life example. If you're going to see a broken leg caused to a pedestrian by a drunken driver is a single event which may give rise to a criminal case. That is prosecution by the state for the offense of driving with excess alcohol. And how it is giving rise to the civil case, the pedestrians use for compensation for pain and suffering. Clear with this example, both the cases, the criminal case and the civil case?
Yes, it is clear.
And rest of you, clear?
Yes.
Okay. So the two sorts of proceedings are usually easily distinguished between the three vital factors are different. So the court where the case is heard, the procedures and the terminology. So in criminal cases, the rule of evidence are usually very strict, right? For in terms of criminal cases, evidence is required. A strong evidence is required in order to pass the judgment. For example, a confession will be carefully examined to see if any pressure was brought to bear upon the accused. So everything is properly analyzed. So an admission in a civil case will not usually be subject to such scrutiny, right? So in civil case, as you've seen, a compensation is being charged. Okay, while in criminal case, any kind of punishment might be given, right? A harsh punishment could also be given depending upon the type of crime being conducted. Okay, so it depends. So in criminal case, all the situation is being carefully examined. Now comes the common law systems. I have given you the brief introduction about the common law through the PPT. Now we're going to study in detail the common law. The common law system derived from and named after the law developed in England between 1066 AD and about 1400 AD. Can you see? Way back. So the common law, although the law was developed in England, it has been exported globally as a result of the British Empire and the Commonwealth. So it is the basis of the legal system of the US. We shall use England and US as the exemplar of the system. You should note that the England has been part of the UK for over 300 years. Some of England's legal system remains peculiar to itself, but many modern aspects are common to the other nations, that is Scotland, Northern Ireland and Wales. You will find both England and UK refer to this in the course book. It is for your information only. Now comes the key principles of the common law. There are 3 principles. Let's look at the first principle. So the principle of law do not become inoperative through the lapse of time. So law does not become irrelevant and invalid just because it is being old. This applies to all sources of the law. So why do you think this has been given? If I'm going to ask you, till now, what have you understood by the term common law? So what will you answer me? Any one of you? Just in your own terms. It's not that you have to give me a correct answer. Whatever you are understanding, just give me a brief in your own terms. Like, what have you understood from the common law? Any one of you? No one? Anyone could write also if you want. We are not willing to speak. You can write and tell me. At least I'll get an idea you are understanding the concept, the common law system. What is it? Yeah, all kind of law is there to protect the rights of the people. But if I'm going to ask you about the common law, why, like, what was the basic rationale behind that? If anyone could remember. So this will help you, enable you to be more vigilant in the class also. Like whatever topic I'm explaining to you, you're getting it. It is very important for me to know. Okay, it is basically, you can say, the law system. Yes, correct. You're right, Roshan. It is basically on what he has written is based on the court rulings rather than the written statutory law. Okay. They're not following the written statutes or the formal codes. They are basically following or whatever the judicial decisions has been taken or the precedents that are being followed in terms of this. Okay. Clear? So if, for suppose, they are following the judicial precedents are being followed, for example, whatever the rulings are being made or decisions are being taken. So don't you think that the law, it will become inoperative to the lapse of time, or it will, you can say, it will become irrelevant or invalid? Yes. So law does not become irrelevant or invalid just because it is being old. So whatever the judicial ruling has been made, whatever decisions has been taken, you have to follow that. Okay. Or whatever case come or a case similar to that, it will apply to it also. But this doesn't happen in the civil law or the criminal law. New laws do not alter the existing law. So the new laws that is being developed by the legislature, the parliament, are presumed not to alter, but merely to add to the existing law unless they specifically state otherwise. Okay, it will not alter. If a new law is coming, it will not alter the previous, whatever the common law is in there. Now comes the judicial precedent. So a judge is bound to apply a decision from an earlier case to the fact of the case before them, provided among other conditions that there is no material differences between the case. He is bound to apply, the judge, he or she is bound to apply, okay, the decisions that are being taken from the earlier case. What is a precedent? A previous court decision which another court is bound to follow by deciding a subsequent case in the same way. Now comes the source of law, that is the sources of the common law. There are various sources of law in England. First is the common law, the equity based on case law, statute, and the customs of little modern significance, or so we shall not consider it anymore. So the US also has a significant additional source of law, that is the American Constitution. American Constitution is the ultimate source of law in the US. So any statute that is being passed by the American Senate, by the federal government, or in individual states may be challenged by a citizen on the ground that it is unconstitutional. Okay. So the US Constitution, what does it do? It sets out the basic rights of the US citizens and the systems of government for them. So you can, if you want, you can access it on the internet. Okay. And the UK does not have a written constitution. Now comes the equity. So what do we mean by equity? Equity is basically developed between 200 or 300 years after the common law as a system of law being applied by the Lord Chancellor in situation where justice did not appear to be done under common law principles. So common law, the body, just give me a minute. The common law is the body of legal rules that common to the whole country, which is embodied in the judicial citizens. So if I'm going to say as a system of law which is being applied by the Lord Chancellor, okay. So equity is a body of law which is being developed, I would say in a normal terms, what I'm going to say, is to supplement the rigid rules of the common law. For example, if any judicial decisions has been taken, which is very strict, harsh. So it is basically equity is there, which supplements the rigid rules of the common law, focusing on the fairness and justice in the situations where the application of the strict legal rule would lead to the unjust outcomes. In order to protect it, is equity is there. So equity basically developed an English legal system to address cases where common law was too inflexible to offer appropriate remedies. See, common law, what is happening? They're following the strict law, whatever the judicial ruling is being given, they're following as it is. So in order to what happens, there was some unjust you can say outcome was also there. So due to it, it was being introduced the equity, which makes more flexible and providing more you can say appropriate remedies. So who is the Lord Chancellor? Lord Chancellor is, you can say, the high-ranking official in the UK government, and their primary role is basically overseeing the judicial system and supporting the Lord Speaker in the House of Lords. So Lord Chancellor is that. So equity, if you're going to see in terms of the definition, it is a term which applies to a specific set of legal principles which are being developed by the Court of Chancery to supplement but not to replace the common law. Okay, it is only supplementing the common law. It is not replacing the common law. It is based on the fair dealings between the parties. It added to and improved on the common law by introducing the concept of fairness. So a key principle states that where equitable rules conflict with the common law rules, then equitable rules will prevail. Clear? A question might come in terms of, you can say true or false also. Or this line will be given like which of the following line is correct. So if it could ask that a situation might come where it states that equitable rule is conflicting with the common law rules. Now, which one will prevail? Tell me.
Equitable rules.
Right. Equitable rules will prevail if, for suppose, any of the scenario comes where there is a conflict between both of them. So equitable rule will prevail. Clear? Now comes the changes that are being brought by in equity. So interaction of the equity and common law that is being produced by the three major changes. That is, first is the new rights. So equity that is being recognized and protected rights for which the common law gave no safeguards. Okay. Then comes the better procedure. Equity may be more effective than common law in resolving a disputed matter. Don't you think it is more flexible?
Yes.
Right? So it will be providing more effective resolution. Then comes the better remedies. So standard common law remedy for the successful claimant was the award of damages for the loss. The chancellor developed remedies not available in other courts. So now comes the equitable remedies. It is available to a claimant under equity include specific performance like an order which is requiring the defendant to do what they had agreed to do. Then comes the injunction, an order which is requiring the defendant to abstain from the wrongdoings in future. They can ask them. Then comes the rectification, that is an order which is requiring a document to be amended to reflect the party's true intentions. Then comes the rescission, that is an order requiring the restoration of the pre-contract status quo. Now comes the case law. So the common law and equity, they form what is known as the case law. What happens is sometimes the court pass ruling based on the case laws, right? This case law reference is being given by this judgment is being passed as we read in the newspaper also. This case law was there. This case was being referred, right? So here this means that common law and equity form what is known as the case law. So case law is a significant difference between the common law system and the civil law system. So case law, they basically incorporates the decisions that are being taken by the judges under both historic legal system, and the expression common law is often used to describe all case law, whatever its historic origin. So a court's decision is expected to be consistent with the previous decisions and to provide an opinion which can be used to direct the future relationships. So this is basically the, you can say the system of the judicial precedent. Clear? Clear till now? The common law, equity. Now comes the statute. So statute, you can see, is made by Parliament in exercise of lawmaking powers that is being delegated by the Parliament, which is known as the delegated legislation, or in the civil law system known as the administrative legislation regulations. So in the UK legislature, Parliament is said to exercise parliamentary sovereignty. This means they can make or repeal laws as well as overrule or modify case laws created by the judiciary. Okay. So the UK tradition is basically to draft the statutes in the comprehensive detail to attempt to cover all eventualities that the statute is designed to cover. Now comes the codification. So from time to time, Parliament will produce a codifying statute which puts common law in an area on a statutory footing. In that respect, codifying statutes are similar to the civil law codes, which we will consider later. However, codification is not common in England, and many areas of law, for example, contract law, still largely derive from the common law. Contract law still largely derived from the common law. So, Okay. Now comes the role of judges. So the judges, they basically play two roles in building up case laws in common law system. That is by setting and applying judicial precedents and by interpreting statutes. They also perform important function of the judicial review, right? So if I'm going to ask you the two roles which is being played by the judges, what are they? You all there? Okay, I'll just see the chat. Yeah. Okay. Fine. So if you're going to use the more technical language, then it is like applying judicial precedents and interpreting statutes, right? Clear with the judicial precedents? And interpreting statutes, right? I've explained it to you in detail, both the terms. So try to use these terms now. Okay? So it will help you to understand and have a grip on the subject well. Whatever you are giving me, the answer is correct, but try to be like, okay. So they also perform the important function of the judicial review. So the English legal system, they comprise of the hierarchy of courts in terms of the status of the courts for precedents. You should be aware that lower courts do not create binding precedents. So do India have the hierarchy of courts? Yes. So what is being given over here? That in terms of the status of the courts for precedents, you should be aware that lower courts do not create binding precedents. What does it mean? What do you understand by this line? Anyone try just once. Now you are getting aware of the language of the law, so I am hoping you to answer this question well. Lower courts do not create binding precedents.
Like lower courts only follow the rules that is already in
Being
force.
decided by the higher courts, right?
Yeah.
Okay. So they are bound by the decisions of the higher courts, each of which is being bound by the court higher to itself, right? In the hierarchy. Clear? Now comes the judicial precedence. So when deciding a case, a judge decision is expected to be consistent with the previous decision. It should provide an opinion which the parties and others can use to direct their future relationship as it creates law. So this is the basis of the system of the judicial precedence. So it is basically based on the three elements. First is the reports. So there are comprehensive law reports of the earlier decisions that are being taken. Then comes the rules, that there must be rules for extracting a legal principle from a previous set of facts and applying it on the current facts. Then comes the classification, that is, precedent must be classified into those that are binding and which are merely persuasive. That is, decisions of lower courts are never binding. Okay, just mark these words properly. When you're having these book, just go through the class once again, whatever I'm guiding you or making you mark as important, just mark it, okay? Because what will happen if you're having this objective type question, not be getting very direct question. It will test your knowledge. Like it will ask you in this manner only. So tomorrow I will be solving with you all the questions from this chapter after completing it. but then you will have a more better idea of the way of the questions that are being asked. But whatever during the class also, whatever I'm telling you, this is important, just have a proper look at it, okay? Then comes the, and secondly, it is an on-demand exam. I've confirmed it, okay? It is the only skill level exam, which is on demand. And it is a 2-hour exam, okay? Then comes the 4 rules that must be considered when examining a precedent before it can be applied to a case. So a decision that must be based on the proposition of law before it can be considered as a precedent. It may not be a decision that is based on a question of fact. Secondly, it must form part of the ratio decidendi of the case. Now, what is ratio decidendi? It is the principle which the judge had followed coming to their decision. In other words, it is the reason for their decision. Then third, the material facts of each case must be the same. And fourth, that is, the preceding court must have had a superior or in some cases equal status to the lower court, such that its decisions are being binding on the later court. Clear? Now comes the avoiding judicial precedents. So a precedent that is being there from the previous case can be avoided by the judge in following ways. So what are the circumstances in which it can be avoided? First is distinguishing on the facts. That is, a precedent is only binding if the material facts of the later case are the same as the previous one. Are you clear with this? The material fact should be the same or somewhat similar. If the material facts are not same, don't you think it will be binding?
No, it is very nice.
It is a matter of the judicial judgment. I want all of you to please participate. Either in terms of chat also you can do. No major changes are there. I'll share with you the PDF also on the group. Like whatever the in different subject changes are there, for law it is not there, okay? Very minor is there. You can use the last report, okay? Second comes the overruling, that is, precedents may be overruled by higher courts than court that set them. So this tends to be rare, particularly if the precedent has existed for a long time. Then comes the per incurlum, that is when an earlier decision was being made without care. Irrational decision was being taken. So these are very, you can say, subjective, okay? So these are the few instances you can say where the precedent that was there from the previous case can be avoided by a judge. So precedents can also be avoided where they have been subsequently overruled by a statute. For suppose a statute is being introduced and it is the case where it can be avoided where it is being subsequently overruled, okay? So this is also the scenario, okay? Mark it as important. Then comes the statutory interpretation. So when you can say when deciding the cases that are being based on the statute law, judges will be required to interpret the statutes that Parliament has enacted. So there are various rules and presumptions that are being associated with the interpretation of the statute, right? Presumptions of statutory interpretation, that are the principles that must be assumed when interpreting a statute, is first is statute do not override the existing law. That is, on a subject unless they specifically state that they do so. In other words, statutes are generally seen to supplement the existing case laws. Then a statute does not alter the existing common law. That is, if a statute is capable of two interpretation, for example, two or more interpretation could be derived. So one involving alteration of the common law and the other not. So the latter interpretation is to be preferred. That one will not be preferred, which will be altering the common law. Then comes the if a statute deprives a person of their property, say by nationalization, so they are they are to be compensated for its value. Statute is not intended to deprive of their liberty. You can say that if it does so, clear words must be used. So this is relevant in legislation covering, for example, mental health and immigration. A statute does not have a retrospective effect, that is to a date earlier than it's becoming a law. Then comes a statute does not bind the crown. In certain cases, a crown's potential liability is great. So therefore, an extremely important presumption. Then a UK statute has effect only in the UK. So do you think like one company statute will be applicable in the other country?
No, I think in my opinion it is not.
Yeah, sorry.
In my opinion, it is not applicable.
Yes. So, however, a statute does not run counter to international laws and should be interpreted so as to giving the international obligation. A statute cannot impose the criminal liability without proof of guilty, without having the proof of guilty intention. So many modern statutes they rebut this assumption by imposing strict liability, say for dangerous driving under the Road Traffic Act. And a statute does not repeal the other statutes. That does not, you can say, does not contradict with it. Any point on which the statute leaves a gap or omission is outside its scope. Now comes the rules of statutory interpretation. So I will continue with this tomorrow in your next class. Till now, it will be very hard for you to get so much of in the single day. So tomorrow I will continue with it. If you're having a book, please go through it once again, whatever I have taught you today in the class, so that tomorrow, if you're having any question, you can ask me, okay? And I will recommend you to please go through it once. Since it's your first day, I will not overload you with the, you can say, the too much of teaching. For today, it is sufficient. And tomorrow I'll continue with the chapter. I'll try to solve the questions as well from the practice kits so that you have the command, like how to go or like how to go through the subject while doing the further chapters. Okay. Any question till now you have?
No, ma'am, it is clear. So
Okay.
I just have one small question apart from the subject, like how long it will take to complete the subject, just to have an understanding.
How long? Sorry, your voice is not audible.
Hello, it's not audible.
Yeah, there's a distortion in the voice. Can you please repeat it again?
Hello, I'm sorry. I think I have some network issue.
Okay,
Is
fine.
it
Now,
audible now?
yes, yes.
Yeah, so I have a question that how
Yes.
long it will take to complete the subject?
Yeah, it will be taking like 2.5 months on an average, like for mid of, you can say, February.
Okay, okay.
Yeah.
Just to have an understanding.
Yeah.
Thank you.
Yeah. Clear? Okay, then I'll continue with the class tomorrow. Fine. Any questions? Anyone else? Okay. Okay. Thank you. Bye.